Welcome to Knowledge November for 2017. In this first video I want to talk about a recent case that's been to the European Court involving a case from Romania of Barbulescu. You may be thinking, well, Brexit, we don't need to worry about this European law anymore, do we? Practical reality is that day one of us being outside of the European Union, the case law would be imported by the law that's being drafted at the moment into our law at that point anyway. So it is worth knowing about. This case involved an employee who was provided as part of his job with a chat facility where he could communicate with his manager, for example, using a particular messenger service. And there are lots of these in use in the workplace today, maybe used instead of email, for example. He had misused the system effectively. He'd been sending his fiancée inappropriate messages, and there were obviously concerns about him being distracted from his job in doing that. And at the lower levels, the employer had been successful in arguing that it was their system. They provided it for his use to do his job, and he was obviously misusing it, and that they had a right to obviously monitor and look at that usage to make sure it fell within terms of the contract of employment, etc. He has appealed that all the way to the European Court of Justice, and the Grand Chamber, very grand sounding body indeed, have decided that employers have got to be very, very careful, and that whilst you might have legitimate reasons for wanting to, for example, check what somebody's activity has been on such a system, that not only have you got to have a legitimate reason for doing that because of the potential interference with privacy, but that you need to have drawn the employee's attention to that. So this particular employer got into difficulty because they hadn't set out in a policy to staff, by the way, your use of this system isn't private, we can look at what you're doing. And this, I think, translates over into social media policies. Lots and lots of people will think that what they do outside of work, or perhaps during a lunch break, in terms of their social media activities, isn't work, so it's nothing to do with my employer can't look at it, my employer can't see it. And one of the things that we need to be making sure that we do in our social media policies is that we educate our staff to make them understand that, by the way, we may decide to look at your activities for the following reasons. Obviously, we've got to balance out privacy against what our legitimate reasons for doing things are. But it's about making people aware, by the way, we can look at this. So it's worth going back to your computer use policies, telephone policies, anything that you have in place in your staff handbooks, and making sure that if you do need to access that information to monitor for some reason, for example, for disciplinary purposes, that you have spelt it out to employees that you have got that potential right and that you may use it. Certainly, I think if I looked at the average computer use policy, it probably refers to email. It probably refers to perhaps what internet site somebody's looking at and whether that's appropriate. But it probably doesn't capture social media. It probably doesn't capture looking at these sorts of chat rooms and other facilities and apps and things that everybody is now using. So there's probably a little bit of updating work to do. If you do have any questions, do give me an email, adenton@refreshinglawlimited, or one word, .co.uk. Thank you very much.